All right, this is the overview of chapters 4 and 5. Since I've already kind of talked about chapter 4, I'm not going to spend a lot of time going over it again because I don't want to bore you to death. But I will just kind of rapid fire go through chapter 4 and kind of get you thinking about it. The initial orientation phase, what are some things that I want you to be thinking about when you're starting out? Probably the biggest thing that I want you to think about is the fact that beginnings matter. Now think about this. You go into a job interview. What are you told by every expert on the planet? That immediate first few moments really make a huge difference. Initial impressions matter. Look, it's just a human nature thing. You've learned that, quite frankly, just by being alive and meeting people and being around. Uh, what happens at the beginning of things matters. Think about, a football game or a sporting event and the initial opening few moments. That can matter. It can matter a great deal. It sets the tone. Uh, in the law practice, and this is a practical pointer for those of you who are going to be litigators in particular, when you go to try a case, when you go to argue a motion, when you go to stand before any kind of tribunal, whether it be a court, a trial court, or a administrative tribunal of some sort, what you say right at the beginning makes a big difference. And why is that? Well, because people tend to remember things that happen right at the beginning of an event or a conversation or a meeting, and they tend to remember what happens at the very end. Which they remember better is a subject of a lot of debate, but we know that from lots of sociological study that what happens in the middle doesn't make as much difference, and so we do know that beginnings and endings matter quite a bit. Just think of somebody writing a book or a story. The beginning matters. Edgar Allan Poe, one of his short stories is called The Cask of the Amontillado, and it starts with 1,000 injuries Fortunato had borne upon me, or something like that, and you sort of get right from the beginning, things ain't going to go well for our buddy Fortunato, ironically given his name. So that's what I'm talking about at the very beginning of things. So keep that in mind, that beginnings matter, and that's why Gifford spends a whole chapter with initial orientation, because beginnings make a big difference. Generally, and I really am going to move on to chapter 5 in just a minute. I really do want to keep this pretty brief on chapter 4. The main thing I want you to recognize is that at the beginning of the negotiation, lots of things are going to kind of be swirling around. You may have issues of agenda control. You may have issues of negotiation site. You may have issues of negotiating arrangements in terms of the physical arrangements at the site. Um, those kinds of things are things which you have to acknowledge and understand and prepare yourself for, and recognize that for the most part, for the biggest measure, those things matter only to the extent you let them matter. They tend not to matter so much if you kind of don't let them bother you. So the best rule there is just kind of let it go. Try to avoid letting those things entangle you and become a big issue. Sometimes clients will insist on certain things, and I think it's always best to counsel your client that you're not going to let these kinds of things really affect you. The negotiating site, the physical arrangements at the site, whether they have you sitting, maybe you've seen the movie It's a Wonderful Life, and the main character, George, comes in to see Mr. Potter, the nasty villain, and Potter is going to offer George a job. And so Potter has George sit down across from him. They're sitting at Potter's gigantic desk, and George sits down and sinks down and really low into this, he's really literally sinking down into this chair and looking up at Mr. Potter. Well, if somebody tries to pull that kind of nonsense on you, you just need to ignore it, frankly. That's just silly, and that just shows weakness on their part, in my opinion. That's just my own opinion. And I know attorneys who they insisted on doing depositions at their office all the time, or they insisted on meetings always being at their office, as if they thought they gained some significant advantage of being at their office. And my attitude was fine, I don't care. And the reason I did that was because I learned that if I didn't let it bother me, then it didn't bother me. It was just that simple. So that's kind of the biggest thing I want you to get out of the idea of this, many of the things that Gifford talked about in chapter 4 in terms of initial orientation, especially related to competitive tactics and the things that people do to try to put you ill at ease, thinking that's going to somehow garner them some sort of advantage. One of the other things people will do is they will fake, and I mean this, they will fake, and lawyers will do this to you, they will fake being all bent out of shape about something. They really aren't. They're just doing it because they think, oh, I can push this guy around. They're a bully. Some lawyers are bullies, and they'll behave as a bully. And if you run across one of those lawyers, best thing to do is just ignore it and move on. Don't get caught up in the tit for tat. Don't get caught up in the back and forth. Don't get caught up in arguing about whether who's going to make what move first and those kinds of things. When somebody tries to draw you in to that kind of discussion, what they're trying to do is just flummox you right at the beginning. The best advice I can give you is don't let them. All right. Briefly, what about cooperative behaviors to start? If the Des Moines experiment from the last unit tells us anything, it tells us that when you start out high, whatever that means in your context, whenever you start out at the extreme, or at least at a very a place that's very far away from the middle, so to speak, from where you expect to be when you finish, you tend to get a better result. And so my advice is that for the most part, unless you really, really know the other negotiator really well, and you have a really great relationship from many prior negotiations, and you both know where you kind of need to be in order to get the matter resolved, and you both kind of know it right from the beginning, and that may very well happen to you over time as you get to know people and you get into a community of lawyers that you deal with regularly, or a community of negotiators that you negotiate with regularly. You may very well find yourself in that position, but until you do, my personal advice is don't start out cooperatively. I mean, it's just the best piece of advice. Just don't do it. It's probably not a smart idea. Particularly if you're dealing with someone like me who's got a lot of gray hair. You start out cooperatively, and I'm going to take every advantage to just tamp you down as much as I possibly can right from the gate. I'm going to see that as an immediate sign that you aren't sure about what you're doing, you aren't sure about your case, you're not sure about your client, whatever. I'm going to immediately, rightly or wrongly, I'm going to assume those things, and it's like raw meat to a Doberman. I'm going to start chewing on it, and I'm going to get really fired up at the idea that, you know what, I can take this guy and really push him way down, and I'm going to look like a genius with my client. They're going to love me and think I'm the greatest lawyer ever because I was able to really push this person down. So best idea, avoid it, again, unless you really know the person or unless you have some really good insight about the case. Kind of stay away from too much initial, really super duper cooperative behaviors. What about initial emotional outbursts at the beginning of a negotiation? And again, my advice, quite frankly, is simply the same thing. Just don't let it bother you. Don't let it draw you in. Be the bigger person, all right, and just move on from it. All right, what about information bargaining? That's chapter 5. Let's talk about that. And this chapter's got a lot of stuff that you need to think about. And some of it I'm going to emphasize, and some of it I will tell you that, in my opinion, you need to be careful about getting too wound up about it. Let's start off with offhand comments that people make. Especially if you're in a negotiation where you are negotiating face to face, and somebody offhandedly comments about anything. I don't care what it is. Don't be so hypersensitive that you're taking every single word the person says as having some kind of major impact on the negotiation. It may or it may not. But if they're suddenly talking, they're saying, "Hey, what do you think about the weather?" don't read anything into that immediately. Best to take people at face value, especially at the beginning. Oftentimes there'll be a little small talk. If the person might tell you a little bit about themselves, and that may provide you some insight. If they want to talk about the weather, then maybe that tells you that this person likes to engage in some basic idle chit chat before they get to the meat of the topic, and so you just go along with them. If you're the kind of person who likes to engage in some idle chit chat, make sure it's idle. Okay, talk about the weather, talk about the football game, whatever it is. Uh, Make sure it's something that you don't really give away anything. But the truth is, you are giving away something no matter what you do. I mean, let's face it, when you first meet somebody and you get into some basic discussion, oftentimes you get to know a little bit about the person, even through a few minutes of what we term idle chit chat. So don't kind of keep your ears open, but don't turn it into a complete psychological profile of the other side. I guess that's all I'm saying. Questions, I've already said it once in this, but I'll say it again, questions unasked, questions unanswered. If you have questions, ask them. What are some things you need to know about the kinds of questions? Sorry about that. It's the kinds of questions that you need to ask. Well, first, ask open-ended questions as often as you can. Some people will just fill the void. And here's the thing, and this is something for you, again, for you prospective litigators, although this works in many areas. If you have kids, particularly teenagers, ask an open-ended question and then just sit there. And silence can be an incredibly powerful weapon in your hands. I can tell you from many years of experience of standing in front of juries and asking questions that oftentimes standing there having asked a question of a witness and then just standing with my hands open and just looking at them and kind of going, just staring and waiting. Well, a void opens up there, and the same void will open up if you're negotiating. The understanding is that you're going to be talking. And so this is particularly true in face-to-face negotiations. If you ask a question, there's an understanding they're going to answer. Don't force it, and don't get anxious, and don't feel this compulsion that I gotta hurry up and get them to answer. I gotta get them to answer. No, you don't. Just wait. Give that silence time to fester, okay? Because they know that you're expecting an answer. And they understand, the other side understands you're expecting an answer. So they let that silence fester. Train yourself. I mean, train yourself to do it. Practice. I'm not kidding about this. It's a powerful, powerful way to get people to talk. It's just to sit there silently and just wait. See, even those few moments that I just said nothing were awkward because the expectation is I'm doing this thing, I'm lecturing, and you're going to hear me talking. Even those few moments of silence are just awkward. So use that. Listen carefully to the other side's questions. When they ask you something, listen carefully, because when they ask you a question, they're exhibiting a concern about their case or their matter or their side of the negotiation. So keep that in mind. Ask why. You know, put yourself into 5-year-old mode and say, well, why? 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 Because when you ask why, again, there's an understanding, and we all get it socially. And look, if you're in bargaining with someone, especially for those of you who are in this course, you're going to be bargaining at a reasonably sophisticated level for the most part. And so when you ask why, people get it. And they know they can't get away with one-word answers. And they understand that implicitly. So asking why is a really good way to do it. I have this thing I call picking around the edges, and one of the things I mean by that is ask don't ask direct questions sometimes. Sometimes you need to ask questions that seem tangentially related to what you're trying to get at. Instead of directly asking something like, well, let's say you're negotiating a lease, and the landlord, let's say it's a commercial lease, and the landlord has said, well, we have to have 28 feet per square foot. That's a pretty, well, I don't know in this market in these days, I don't know, but in my day, which was my heydays long gone, that would have been quite an astronomical amount in the places where I lived and worked and negotiated. 10, 12 bucks for a decent space would have been more like it. Instead of just saying, wow, that's ridiculous, why would you want $28 a square foot? Ask a different question. Ask a question like, well, how do you feel about how do you feel about increasing the length of the lease? Or how do you feel about some other issue in the lease? Pick around and, what concerns do you have about coming to this amount per square foot? Or, try to come up, don't just bluntly dive in, just kind of work your way around. Ask different questions. You have to, kind of think through what kind of questions you're going to ask, but just pick around the edge of why they're trying to get $28 if that's a ridiculous amount. Use closed-ended questions sparingly, and use them generally when you're really at the end of the negotiation, not at the beginning. What about baiting the other side by throwing something out that you know is going to get them going? I think that's more a matter of kind of deciding if you're going to do that kind of thing. That needs to be planned intentionally, and it needs to be done very well, because it could really mess things up. So you have to be very careful and very thoughtful about doing something like that. And by baiting, I mean you throw out something that you know is going to get them wound up right at the beginning. In my day as a defense attorney doing insurance defense work, oftentimes if it were appropriate, I might throw out a ridiculously low number to settle a case at someone to try to bait them in to see, just to sort of see how they reacted and to see if were they going to go nuts on me or were they less nutty. And if they kind of hemmed and hawed a little bit, then maybe I knew they had some problems with their case that I didn't know about. If they blasted me, that was less valuable, quite frankly, because it could mean they're just faking and acting upset when really they know that's not a bad offer. Or they could be genuinely distraught that I would make such a ridiculously low offer. So when the results of it sometimes are not necessarily completely discernible, so I'm not sure I think it's a great tactic, but again, it's something if you plan it and you try to use it effectively, it may get you somewhere. I don't recommend you do it all the time. I don't recommend it be your standard starting point, because once people learn that, they'll ignore it. I had an old boss, again, another little war story. I had an old boss who he was unbelievably predictable, and over time I learned that he always did things a certain way, and once you kind of knew that about him, it made his tactics much less effective. And I learned that when I became a defense attorney, I ended up having some cases with him, and I knew that he reacted in certain ways, and it made it easier to deal with it. So keep that in mind. You may, if you do something all the time, you may find yourself at the short end of the stick with people, because they'll learn your MO. Of course, you'll learn their MO as well. What about paralinguistic and nonverbal cues? I'm talking about things like eye contact, shifty eyes. Somebody's squinting all the time. They're doing their Clint Eastwood impression. They look away all the time, and they won't make direct eye contact with you. It's kind of freaky, isn't it? I mean, just even on a video, it's like, people fidgeting, they're constantly tapping their foot, they're jingling their keys, whatever it might be. What do you make of those things? Gifford gives a little more emphasis to that than I would. I just think you have to be really, really careful about putting much emphasis on these things. I do this sometimes. Does it mean anything? No, it's just a bad habit that I'm into, that sometimes I will rub my beard. I've had a beard for 15 years, and or really, yeah, even long, 15 years or more. Well, my son's 15, my younger son, I grew it when he was born, so there you go, 15 years. Well, what does it mean? It doesn't mean anything. It's just a habit, and it doesn't indicate anything. And if you start reading in, oh yeah, when somebody tugs their beard, it means A, B, or C. You just need to be really careful about those kinds of things. Once in a while, I remember watching an attorney in my office cross-examine a doctor who literally was trying to argue with him about a comma and what a comma meant in his medical record. And as he was arguing, he was sitting in the witness chair and he started slouching and literally slouching down. And the fact of the matter is that the jury got the message. He wasn't being honest. He wasn't being straightforward. So that could matter. I think it's more important to focus in on what people are saying. What are they actually saying? And again, this obviously only applies in a face-to-face situation. If you're doing an email, you can't see someone's face. Couple of nevers. And I say these with much fear and trembling, but I will say them anyway. Never say, to be honest, okay? Never use the phrase, to be honest. And let me give you an example. Well, to be honest, we really want to get $28 a square foot. Why shouldn't you say, to be honest? Well, because almost inevitably, people assume that when you say that, you're getting ready to lie. That's just the reality of it. If you are someone who likes to use that terminology, try to tear it, rip it, throw it away, get it out of your vocabulary, stomp it on the ground, burn it, send it to outer space. Every possible thing you can do with that phrase, get rid of it. And again, there's variations on the theme. Well, honestly, well, when people say that, why do you have to say that? You're either honest or you're not. And if you're going to be honest with people, you don't need to say that you're being honest. You just tell them stuff. So just, just to be honest here. Well, you mean you haven't been honest with me the whole time? I mean, huh? What? Those kinds of terminology, that kind of terminology, you need to just exercise it, okay? Just get rid of it. Okay, just an exorcise, not exercise. Exorcise, push it out. Never say it's the money, or never say it's not the money. I'm sorry. Never say, oh, it's not the money. It's the principle. If money is involved in the negotiation, then it's about the money. At least to some extent, it's about the money, and it's highly unusual and highly difficult to believe that it's not about the money when there's money involved. So just, again, don't say it. Don't say, oh, it's not about the money. Yeah, don't do it, okay? Nobody's going to believe you anyway. What about off-the-record discussions? By this I mean, you've seen them in the courtroom, the two attorneys go up to the judge, can we talk off the record? Those are fine. And those are perfectly legitimate. The one thing that needs to happen, though, is the other attorney needs to reciprocate. Now, what does this look like in practice? This comes up when usually this comes up when you've been doing some back and forth, and you need to tell the other attorney something, or you want to let them know something that's going to impact the negotiation, but you want to let them know that you don't want them blabbing it to their client. And so oftentimes I might contact another attorney and say, listen, just between you and me, and I mean, you need to really keep this between us. And I knew the attorneys I could trust. I would, and that's the other key feature here. You can't have an off-the-record discussion with someone that you're not sure you can trust. Don't ever do that. And, but I would say, look, I've got this problem with my case. I haven't really given it a lot of discussion. I know you've been thinking it's a problem. Well, I'm going to tell you, I admit that I don't think my witness X is going to quite say what we thought witness X was going to say, and here's, I understand the implications of that. I'm not admitting this at this time officially. I'm sort of admitting it clandestinely to you so that you know that that's where I'm coming from, and you use that in whatever means, whatever way you think is necessary. You can do that sometimes, but you have to be careful. Information concealment. There's two things going on here. One is actually doing it, so actual avoidance techniques, and by that I mean things you can do to avoid saying what you want to say. Don't answer the question and shift to some other topic. Somebody asks you a question, you see politicians do this all the time. Sir, what's your opinion on immigration? Immigration is a big issue in our country today, and that's why I'm in favor of a new jobs bill. Huh? Well, that's what politicians do. And so sometimes you might need to find yourself doing that, is to move away and find something else to talk about. What else? Answer a different question. They ask you one question A and you answer question B, and act like you're answering the question they asked. And then you're going to have to sort of be puzzled when they say, well, that's not really what I asked. What? Oh, gosh. Give an incomplete answer. Answer part of the question. If they ask you a question that what's your position on immigration reform? To just go back to that. Well, I think we need immigration reform. And okay, that's nice. What does that mean? What does that look like? Somebody asks you a question during a negotiation. Let's go back to my old hackneyed lease situation. Well, why is it that you need $28 a square foot? Well, that's what we want. And move on. I mean, I guess you could say that's a complete answer, but it's not really. The person wants to know what's behind it. And what you want isn't what's behind it. There's more to it than that. There's a reason why you've come up with that number. Say that you will answer if they give you something. You can always do that. Well, before I answer that question, why we need $28 a square foot, I really need to know from you why you want a 5-year lease instead of a 3-year lease. Again, you haven't answered the question. You can refuse to answer and just say, I can't answer that question. And you can tell them why if you want to. I can't answer that question because my client told me not to tell you. Sorry. I can't answer that question because it would require me to disclose some client confidences that I can't disclose to you. It's not right. Sometimes you can just say just a little bit. I don't know if I mentioned or did not, and sometimes it runs together, but a phone conversation I had with an old guy that I learned to love after many years, but he just sat there on the phone and would hardly ever say anything, and you would do all the talking. Well, he was smart because he would often sit there and listen, and he knew that people would fill the void with conversation. It's just the way we are. So just only say a little bit. Give out as little information. If the question has a yes or no component, then you say yes or no, and you don't say anything else. All right, what's the ethical consideration? Well, Rule 4.1 requires that you tell the truth. And what about puffing? I disagree with Gifford. He says puffing is basically an exception to the rule, the ethical rule. If you were an attorney, Rule 4.1, you're going to have to read it, and you're going to have to come to your own resolution in your own mind and heart about what you feel. As a Christian, I think I feel compelled to tell the truth, obviously, and I just think you have to find ways to get around lying. I mean, I'm talking about bluntly lying to someone. Well, will your client accept $10,000 when you know your client will accept $10,000? You can't say no. You just can't. You really have to find a way to get around that. So if you know your client will accept 10,000 for whatever I'm talking about, but you think you can get the person to give you 15,000, then you say, my client would be thrilled to get 15,000. Well, of course they would. They'll take 10. So obviously, if they get 15 for whatever it is we're talking about, obviously more is better than less. So you can say that. You can say that honestly without saying no. You're not saying no. They won't take 10,000. You're saying they'll take 15,000 or 20 or whatever number you want to throw out there. And maybe by doing so, you get your client some extra money. Maybe you don't. But you avoid lying. And again, you can never just tell bald-faced lies. You just can't do that. You're going to have to, again, I'll move on, but you're going to have to decide for yourself how far you think you can go in terms of puffing. What about argument? Briefly, I'm going to say this about argument, and I know I've gone a long time, so I'll stop with this. Any rational, reasoned discussion is perfectly acceptable. Just a bald-faced, yelling and screaming argument is not. Try very, very diligently to avoid those kind of arguments. Anytime you want to make have a rational debate, try to keep the tone friendly. Always try to keep it on an even keel. But you're certainly welcome to raise arguments. And that goes without saying, especially in legal negotiations. You're going to be arguing about things all the time. That case, the case of Jones versus Smith, it says that, when both parties have, some equal amount of blame, that even in a state where there's a modified contrib, that means that if they're at 50-50, then nobody can make a claim against the other party. That's a simple legal argument, and I think in this case, both parties are 50-50 to blame, and so we ought to both just walk away here and just stop beating our heads on this case. The other side may say, well, but Mr. Smith, my client, he had the right of way in this car accident case. And, your client had the stop sign, and so therefore it's got to be your client's fault. And even if it's, yes, Mr. Smith was going too fast and he was exceeding the speed limit significantly, but that doesn't matter. Just a simple thing like that. Arguments are fine. Just keep them even keeled. All right, well, we'll move on from here and go ahead and study up some and take the quiz. And there will also be a scenario that I'm going to have you respond to in a brief essay form, just a couple pages. I don't need 5 or 10 pages, just a couple of pages for you to kind of give me a sense that you're following what's going on.